4, willfully allowing Ohio Secretary of State John Kenneth Blackwell, acting under the color of law and as an agent of George W. Bush, to issue a directive that no votes would be counted unless cast in the right precinct, reversing Ohio's long-standing practice of counting votes for president if cast in the right county. Willfully allowing his agent, Ohio Secretary of State John Kenneth Blackwell, the co-chair of the Bush-Cheney re-election campaign, to do nothing to assure the voting rights of 10,000 people in the city of Cleveland when a computer error by a private vendor, Diebold election system, incorrectly disenfranchised 10,000 voters. Willfully allowing his agent, Ohio Secretary of State John Kenneth Blackwell, the co-chair of the Bush-Cheney re-election campaign, to ensure that uncounted and provisional ballots in Ohio's 2004 presidential election would be disproportionately concentrated in the urban African-American districts. A. In Ohio's Lucas County, which includes Toledo, 3,122, or 41.13% of the provisional ballots went uncounted under the direction of George W. Bush's agent, the Secretary of State of Ohio, John Kenneth Blackwell, co-chair of the committee to re-elect Bush Cheney in Ohio. In Ohio's Cuyahoga County, which includes Cleveland, 8,559, or 32.82% of the provisional ballots went uncounted. In Ohio's Hamilton County, which includes Cincinnati, 3,529, or 24.23% of the provisional ballots went uncounted. Statewide, the provisional ballot rejection rate was 9%, as compared to the greater figures in urban areas where a substantial African-American population is located. D. The Department of Justice, charged with enforcing the Voting Rights Act of 1965, the 14th Amendment's Equal Protection Clause, and other voting rights laws in the United States of America, under the direction and administration of George W. Bush, did willfully and purposely obstruct and stonewall legitimate criminal investigations into myriad cases of reported electoral fraud and suppression in the state of Ohio. Such activities carried out by the Department on behalf of George W. Bush in counties such as Franklin and Knox by persons such as John K. Tanner and others were meant to confound and whitewash legitimate legal criminal investigations into the suppression of massive numbers of legally registered voters and the removal of their right to cast a ballot fairly and freely in the state of Ohio, which was crucial to the certified electoral victory of George Bush in 2004. On or about November 1st, 2006, members of the United States Department of Justice, under the control and direction of the administration of George W. Bush, brought indictments for voter registration fraud within days of an election in order to directly affect the outcome of that election for partisan purposes, and in doing so violated the Justice Department's own rules against filing election-related indictments so close to an election. F. Emails have been obtained showing that the Republican National Committee and members of Bush-Cheney 04 Inc. did, at the direction of the White House, under the administration of George Bush, engage in voter suppression in 5 states by a method known as vote caging, an illegal voter suppression technique. Agents, G, agents of George W. Bush, including Mark F. Thor Hearn, the National General Counsel, at the behest of George W. Bush, as members of a criminal front group, distribute known false information and propaganda in the hopes of forwarding legislation and other actions that would result in the disenfranchisement of Democratic voters for partisan purposes. The scheme, run under the auspices of an organization known as the American Center for Voting Rights, was funded by agents of George W. Bush in violation of laws governing tax-exempt 501c3 organization, and in violation of federal laws forbidding the distribution of such propaganda by the federal government and agents working on its behalf. H, members of the United States Department of Justice, under the control and direction of the administration of George W. Bush, did, for partisan reasons, illegally and with malice aforethought, block career attorneys and other officials in the Department of Justice from filing 3 lawsuits charging local and county governments with violating the Voting Rights Act of voting rights of African Americans and other minorities, according to 7 former senior United States Justice Department employees. I, members of the United States Department of Justice, under the control and administration, under the control and direction of the administration of George Bush, did legally and with malice aforethought derail at least 2 investigations into possible voter discrimination, according to a letter sent to the Senate Rules and Administration Committee and written by former employees of the United States Department of Justice, the Voting Rights Section. Members of the United States Election Assistance Commission, under the control and direction of the administration of George W. Bush, have purposefully and willfully misled the public in violation of several laws by 1, withholding from the public and then altering a legally mandated report on the true measure and threat of voter fraud as commissioned by the Election Assistance Commission and completed in June 2006 prior to the 2006 midterm election, but withheld from release prior to that election when its information would have been useful in the administration of elections across the country because the results of the statutorily required and taxpayer-funded report did not conform with the illegal partisan propaganda efforts and politicized agenda of the Bush administration. 2, withholding from the public a legally mandated report on the disenfranchising effect of photo identification laws at the polling place, known to disproportionately disenfranchise voters not of George W. Bush's political party. The report was commissioned by the EAC and completed in June 2006 prior to the 2006 midterm election, but withheld from release prior to that election when its information would have been useful in the administration of elections across the country. 3, withholding from the public a legally mandated report on the effectiveness of provisional voting as commissioned by this Elections Commission and completed in June 2006 prior to the 2006 midterm election, but withheld from release prior to that election when its information would have been useful in the administration of elections across the country, and keeping that report unreleased for more than a year until it was revealed by independent media outlets, frustrated the conduct of the 2006 elections. For directly harming the rights and manner of suffrage, for suffering to make them secret and unknowable, for overseeing and participating in the disenfranchisement of legal voters, for instituting debates and doubts about the true nature of elections, all against the will and consent of local voters affected, and forced through threats of litigation by agents and agencies overseen by George W. Bush. The actions of Mr. Bush do the opposite of securing and guaranteeing the rights of people to alter or abolish their government by way of the electoral process, being a violation of an inalienable right and an immediate threat to liberty. In all these actions and decisions, President George W. Bush has acted in a manner contrary to his trust as President and Commander-in-Chief, and subversive of constitutional government, to the prejudice of the cause of law and justice, and to the manifest injury of the people of the United States. Wherefore, President George W. Bush, by such conduct, is guilty of an impeachable offense warranting removal from office. Article 30.